Chapter 10. Slavery on Trial. In the years while Barber had been away, Johnson had become firmly established as a celebrity. His fame had been steadily increasing over the 17 years since he had published his Dictionary of the English Language in 1755, and now almost his every movement or saying was likely to be published in the London press and then repeated a few days later in the provincial papers. Dr. Johnson makes a funny remark: "Dr. Johnson is unwell, Dr. Johnson goes out, Dr. Johnson stays at home." The scholar Helen Louise McGuffey drew up a checklist of Johnson's appearances in the British press between 1749 and 1784. It fills 348 pages. Now a little of this fame started to rub off on Barber. In April 1771 an anecdote appeared in the Town and Country magazine. Dr. Goldsmith, meeting Dr. Johnson with his little lackey behind him, for whom he has a sort of parental affection, asked his learned friend if he intended to bring him up a scholar. "Yes," replied Dr. Johnson, with his usual roughness, "I intend to make him scholar enough to write a bailiff scene in a comedy." The joke is at Goldsmith's expense, as he had written just such a scene in his comedy The Good-Natured Man. The description of Johnson's attitude towards Barber as a sort of parental affection is particularly telling. It suggests that the public perception of their relationship confirmed Johnson's own claim to have treated Barber with great tenderness. As was the usual way, many of the other papers reprinted the squib over the following few weeks. When the London Packet, or New Evening Post published it in July, it was slightly altered. Dr. Goldsmith, meeting Dr. Johnson with a young Negro at his heels, asked, "What do you intend to do with that boy, Doctor? Do you mean to make him a scholar?" "Yes, yes," replied surly Samuel, "I shall make him scholar enough to write a bailiff scene in a comedy." In this version, the little lackey had been more closely identified as a young Negro, an obvious reference to Francis Barber. The joke was regarded as entertaining enough to appear in book form, as it was published in 1773 in John Cook's snappily titled collection, The Macaroni Jester, and Pantheon of Wit, containing all that has lately transpired in the regions of politeness, whim, and novelty, including a singular variety of jests, witticisms, bon mots, conundrums, toasts, acrostics, etc., with epigrams and epitaphs, of the laughable kind, and strokes of humor hitherto unequaled, which have never appeared in a book of the kind. It is apparent that Johnson's determined efforts to ensure that Barber was educated had become public knowledge. Johnson was happy to have his favorite back again. On June 20, 1771, he wrote to his friend Hester Thrale. "This night at 9 o'clock Sam Johnson and Francis Barber Esquires set out in the Lichfield stage. Francis is indeed rather upon it. What adventures we may meet with who can tell?" It was one of several occasions on which Barber accompanied Johnson to Lichfield, and this time they spent almost 4 weeks there. Everything about the note which Johnson sent to Mrs. Thrale concerning their trip suggests the friendly nature of relations between Johnson and Barber. The tone is light-hearted and the pair are both portrayed as esquires, setting forth in search of adventure. It is an attractive glimpse of their relationship, especially given a very different perspective of white-black interaction which could also be seen in Lichfield. Shortly after the visit of Barber and Johnson an auction took place in the city. The commodity for sale was a Negro boy, from Africa, supposed to be about 10 or 11 years of age. Well proportioned, speaks tolerable good English. Sound, healthy, fond of labor, and for color an excellent fine black. The fact that such a sale could take place was a stark reminder of the unresolved issues around the subject of slavery. The threat of being re-enslaved and sent back into colonial slavery had hung over Barber, as it hung over all former slaves, when he arrived in Britain in 1750, and it had remained a dreadful possibility throughout the 21 years which had passed since. Faced with the prospect of being dragged back into colonial slavery, some blacks took the only way out. As late as 1773, an item appeared in the newspapers. A black servant to Captain Ortington, who a few days ago ran away from his master and got himself christened, with the intent to marry his fellow servant, a white woman, being taken and sent on board the captain's ship in the Thames, took an opportunity of shooting himself through the head. But the very legality of slavery in England was about to be challenged, largely as a result of the strenuous efforts of just one man, Granville Sharp. Sharp was a devout lay Anglican, from a family of prominent clergymen, who was employed as a clerk in the Ordnance Office. He was intense and studious, and once his convictions were engaged by an issue he was extraordinarily tenacious in pursuing it. On one occasion he found himself bested in debate about Christ's atonement and Old Testament prophecies because of his lack of knowledge of the original texts, so he quickly taught himself Greek and Hebrew. The incident which turned Sharp into a committed anti-slavery campaigner was his encounter with Jonathan Strong, a former slave. Strong's history was in some ways similar to that of Francis Barber. His owner was a barrister named David Lyle, who had attempted to set up practice in Barbados. The venture was not a success, and sometime after 1757 he returned to England, bringing with him Strong, who was then about 10 years old. Lyle had a violent temper, and Strong was often on the receiving end of his outbursts. As a result of the repeated assaults and ill-treatment, Strong was in chronically poor health. Then, in 1765, possibly provoked by the fact that Strong had recently been baptized, Lyle attacked him again, this time using a pistol as a club to beat him badly around the head. The beating, coming on top of Strong's already frail health, affected his sight and left him so debilitated as to be of no further value to Lyle, who threw him out into the street. Strong was in desperate need of medical care, and fortunately he met someone who told him of a free clinic for poor people in Mincing Lane, run by the surgeon William Sharp. He was barely able to walk or to see where he was going, but he made his way there. As he approached the door, he was spotted by the doctor's brother, Granville. The two Sharp brothers arranged for Strong to be admitted to St. Bartholomew's Hospital, where he received treatment for the next 4 months. Upon his discharge, Granville Sharp found him work with an apothecary in Fenchurch Street and thought no more about the black youth. But 2 years later, on September 12, 1767, he received a letter from Strong, who was in the Poultry Comte, the jail, and was begging for his help. Strong's former owner, David Lyle, had spotted him in the street and, seeing that Strong was once again healthy and of value, had him seized and thrown into prison. Sharp immediately went to the Lord Mayor, who summoned those who had detained Strong to appear before him. On the appointed day, 2 men appeared. One was a notary public, who produced a bill of sale which showed that Lyle had sold Strong to James Kerr, a Jamaican planter, for the sum of £30. The other was a ship's captain, who was waiting to take Strong to slavery in Jamaica. When the facts were set before the Lord Mayor, he pronounced that Strong had committed no offense and was therefore free to go. The captain immediately seized Strong, telling the mayor that he was the property of the Jamaican planter to whom he had been sold. Sharp angrily exclaimed, "Sir, I charge you for an assault." The captain let go, and Strong went free. If Sharp thought that was the end of the matter, he was soon proved quite wrong. A few days later Kerr issued a writ against Sharp, alleging that he had robbed him of his slave and claiming £200 in damages. Lyle attempted a more direct method of revenging himself upon Sharp, by challenging him to a duel. Sharp recorded in his diary what occurred. October 1, 1767. David Lyle, Esquire, a man of the law, called on me in Mincing Lane, to demand gentlemanlike satisfaction, because I had procured the liberty of his slave, Jonathan Strong. I told him, that, as he had studied the law so many years, he should want no satisfaction that the law could give him. Sharp's legal advisers were pessimistic and urged him to settle before the matter came to trial. Sharp was astonished to discover that the law might not be on his side. In his own words, he could not believe that the laws of England were really so injurious to natural rights. Having been failed by his lawyers, Sharp took matters into his own hands. He had never previously opened a law book in his life, yet he searched through the indexes of a law library, looking for ammunition to use against Lyle. For the next 2 years he continued his research, which culminated in a memorandum entitled, "A Representation of the Injustice and Dangerous Tendency of Tolerating Slavery, or even of Admitting the Least Claim to Private Property in the Persons of Men, in England." He circulated numerous copies, especially among the lawyers in the Inns of Court. The memorandum would have been impressive if it had been written by a trained lawyer, formidable research combined with detailed analysis, running to 167 pages in Sharp's printed version. But the fact that it originated from someone who had until recently known nothing at all about the subject made it a particularly remarkable achievement. As it turned out, Sharp's arguments were not to be tested in court in this particular case. During the 2 years in which Sharp had been preparing his memorandum, Kerr had taken no steps at all in his action, with the result that the case was struck out, and Kerr was ordered to pay Sharp's costs. In 1769 Sharp published his memorandum, the first major anti-slavery work to be published in Britain. Over the next few years Sharp took on several cases where slavery was an issue. They culminated in the Somerset case, decided in June 1772, which marked the beginning of the end of slavery in England. The events which led James Somerset to the Court of King's Bench began in 1769 when Charles Stoyart, a Scot working as a customs official in Virginia, came to England for an extended visit, bringing with him a young slave. In August 1771, that slave was baptized James Somerset, at St. Andrews, Holborn. Somerset may have believed that baptism freed him, as in October he ran away from his owner. But his freedom was short-lived. He was recaptured by Stoyart the following month, and put on board a ship bound for Jamaica, to be sold as a slave. Fortunately for Somerset, his godparents intervened and obtained a writ of habeas corpus, which was served on the ship's captain, John Knowles, ordering him to produce the captive and justify his actions. The captain freed Somerset, but Stoyart determined to fight the matter, encouraged by West Indian slave-owning interests, and it soon became apparent that this would be a test case. The case was fought over 4 months and attracted enormous press attention. The principal judge was Lord Mansfield, the Lord Chief Justice, by common consent the greatest judge of the 18th century. Mansfield had some personal knowledge of the position of blacks in England. At the time of the case he had a young black girl, Dido Elizabeth Bell, living in his household. She was the illegitimate daughter of Mansfield's nephew Sir John Lindsay, a Navy captain who had taken prisoner her mother, who was probably a slave, from a Spanish vessel. Dido was taken into Lord Mansfield's household at Kenwood, where she seems to have been part servant and part companion for Mansfield's great-niece and adoptive daughter, Lady Elizabeth Murray. Mansfield's affection for Dido was a cause of concern to those who did not want to see Somerset's freedom confirmed. One Jamaican planter commented, "No doubt he will be set free, for Lord Mansfield keeps a black in his house which governs him and the whole family." This attributed to Dido a somewhat improbable level of influence, as she was only 10 or 11 years old when the case was heard. The trial opened in Westminster Hall on January 26, 1772. It began with the reading of the return, the formal explanation by Captain Knowles of why Somerset had been in his custody. He stated that a trade in slaves from Africa to the colonies had long existed for the necessary supplying of the colonies and plantations, and such slaves were saleable as goods and chattels under the laws of the colonies. Somerset had been bought by Stoyart and had never been set free. He had run away and was recaptured and placed on Knowles's ship to be taken to Jamaica and sold as the property of Charles Stoyart. So the reason he was being held was simple: Somerset was Stoyart's slave and his property, and Stoyart had decided to sell him. At the request of Somerset's lawyers the case was adjourned for 12 days to allow more time to prepare, but it was postponed again when it became apparent that the hearing was likely to be lengthy and could not be completed before the end of that judicial term. It resumed in May. The arguments ranged widely and were unusually lengthy and detailed. Sergeant Davy, one of the barristers appearing for Somerset, opened his case. "My lord, this is as great a question and perhaps a question of as much consequence as can come before this or any court of justice. The proposition I shall endeavour to maintain before your lordship upon this occasion is, that no man at this day is, or can be a slave in England." Both sides quoted extensively from legal writers and philosophers. Grotius and Pufendorf approved of slavery for captives in war. Montesquieu was against, except for purposes of self-preservation. Thomas Rutherford and John Locke were absolutely against it. Aristotle defended it. There was much discussion too of the positions of other countries, both ancient and modern: Scotland, Holland, Spain, France, America, Africa, Asia, Russia, Poland, Greece, and Rome. Somerset's lawyers gave both moral and pragmatic reasons for opposing slavery. It corrupts the morals of the master, they argued, giving rise to luxury, pride, and cruelty. It endangers the master, upon whom the slave desires revenge. It debases the mind of the slave, and threatens the state, the destruction of which is the slave's only hope. But much of their argument centered on the law of England. What did it matter, they argued, if Somerset was a slave in Africa or Virginia? In England, where freedom is the grand object of the laws, and dispense to the meanest individual, shall the laws of an infant colony, Virginia, or of a barbarous nation, Africa, prevail? Moreover, they demanded, could anyone in England tolerate the reality of colonial-style slavery? The horrid cruelties, scarce credible in recital, perpetrated in America, might, by the allowance of slaves amongst us, be introduced here. Could your lordship, could any liberal and ingenuous temper, endure, in the fields bordering on this city, to see a wretch bound for some trivial offence to a tree, torn and agonizing beneath the scourge? There was also much discussion of villanage, the ancient unfree status which, in some respects, resembled slavery. But, argued Somerset's lawyers, villanage was long extinct. There is no law against it, no act of Parliament against it. Why should not a man be a villain? Where is the law? Show the book if you can that forbids it. No such book can be found, but there is the law written in the hearts of men of this country, that is the law, it is the Constitution. True genuine liberty is the birthright and inheritance of the people in this country. If slavery was not a form of villanage, how else could the state of slavery arise? It could not be based on contract, said Somerset's lawyers. What power could there be in any man to dispose of the rights vested in him and his descendants by nature and society? Sergeant Davy closed the case for Somerset by referring to the statement, quoted in Chapter 5, which the judges had made in 1569 regarding English air and slavery. It has been asserted, and is now repeated by me, this air is too pure for a slave to breathe in. I trust I shall not quit this court without certain conviction of the truth of that assertion. Somerset's lawyers rested their case, and it was the turn of Stoyart's counsel. They argued from every angle, legal, moral, and practical. Somerset had been a slave according to local law in Africa, and had been sold according to the laws of the colonies. He was therefore a slave both in law and in fact. There was no law against slavery in England. If the air of England was too pure for slavery, how could villanage ever have existed? Let me take notice, said John Dunning, counsel for Stoyart, neither the air of England is too pure for a slave to breathe in, nor the laws of England have rejected servitude. As to the morality of slavery, the practice was near universal. It is found in 3/4 of the globe, and in part of the 4th. In any event, the worst features of colonial slavery were unknown in England. Particular emphasis was placed on the practical consequences which would arise if slaves were freed. The court must consider the great detriment to proprietors, there being so great a number in the ports of this kingdom, that many thousands of pounds would be lost to the owners, by setting them free. The hearing lasted 4 days. Before adjourning to consider his judgment, Lord Mansfield made it clear that he had urged the parties to settle the case. He was anxious about the possible consequences of a judgment in Somerset's favour, the setting 14,000 or 15,000 men at once free loose by a solemn opinion, is much disagreeable in the effects it threatens. But if the parties were not willing to settle, then so be it. If the parties will have judgment, fiat justitia, ruat coelum, let justice be done whatever be the consequence. The parties did not settle, and judgment was handed down on June 22, 1772. Lord Mansfield's exact words have been much debated by scholars, but it seems most probable that he pronounced, "The only question before us is, whether the cause on the return is sufficient? If it is, the Negro must be remanded, if it is not, he must be discharged." Accordingly, the return states, that the slave departed and refused to serve, whereupon he was kept, to be sold abroad. So high an act of dominion must be recognized by the law of the country where it is used. The power of a master over his slave has been extremely different, in different countries. The state of slavery is of such a nature, that it is incapable of being introduced on any reasons, moral or political, but only positive law, which preserves its force long after the reasons, occasion, and time itself from whence it was created, is erased from memory. It's so odious, that nothing can be suffered to support it, but positive law. Whatever inconveniences, therefore, may follow from a decision, I cannot say this case is allowed or approved by the law of England, and therefore the black must be discharged. Somerset had won, and could go free. But what is striking about the judgment is how narrow the finding is. The judge offered no grand statements of moral principle, no sweeping rhetoric, and nothing about the quality of the air of England. There was simply a finding that slavery can be established only by positive law, by which Mansfield meant statute or well-established custom, and there was no power to send a man abroad to be sold. Mansfield subsequently insisted that nothing had been decided in the Somerset case except that a master could not forcibly send a slave abroad. In spite of the narrowness of the judgment, however, he must have been well aware of the implications. If slavery could be established only by positive law, and there was no such positive law in England, then how could slavery continue? Moreover, how could slave owners prevent their slaves from running away when they had lost their most potent threat, that of sending a slave back into colonial slavery? Certainly the black community thought the judgment a triumph. On the following day the Middlesex Journal recorded that a great number of blacks were in Westminster Hall to hear the determination of the cause and went away greatly pleased. A few days later the London Packet reported that near 200 blacks, with their ladies gathered, at a public house in Westminster, to celebrate the triumph which their brother Somerset had obtained over Mr. Stuart his master. Lord Mansfield's health was echoed round the room, and the evening was concluded with a ball. The tickets for admittance to this black assembly were 5s each. According to the historian Simon Sharma, celebrations also took place at a party at Dr. Johnson's house organized by his servant Francis Barber. It is an appealing idea, but sadly there is no evidence that such an event took place. However, Barber could hardly have been unaware of a case which was so widely publicized and which had such momentous implications for the black community, especially as Johnson certainly did know about the judgment. The outcome affected Barber, as it did all other blacks in his position, making his place in society more secure, removing any lingering doubt that his liberty might be provisional and that if circumstances changed he might find himself enslaved once more. The judgment took on a life of its own. The day after the decision, the Middlesex Journal reported that Mansfield had ruled that every slave brought into this country ought to go free. Numerous other reports in the newspapers and elsewhere gave similar accounts. Edmund Burke wrote that even a Negro slave, who had been sold in the colonies and under an Act of Parliament, became as free as every other man who breathed the same air with him. The news spread further afield to the colonies. On June 30, 1774, the Virginia Gazette carried an advertisement on behalf of one Gabriel Jones, seeking the return of his runaway slave Bacchus. It stated that Bacchus might attempt to get on board some vessel bound for Great Britain, from the knowledge he has of the late determination of Somerset's case. Johnson had followed the ruling closely and referred back to it a few years later when similar litigation took place in Scotland in the case of Knight v Wedderburn. The Somerset judgment did not apply there, as the Scottish legal system was, and is, different from the English legal system, and slavery continued to be practiced. John Wedderburn, a Jacobite who had fled from Scotland in 1746, returned in 1768, bringing with him Joseph Knight, a slave he had purchased in Jamaica. Knight remained enslaved for several years, but then, in July 1772, he read a report of the Somerset case in the Edinburgh Advertiser and believed that it meant he was free. However, he chose not to leave Wedderburn at that time, perhaps influenced by the fact that he had formed a relationship with Anne Thompson, a chambermaid in Wedderburn's household at Belindian. She became pregnant, and Wedderburn seems initially to have been supportive, giving Knight money for Thompson's medical care and, when the child died, paying for the funeral. Knight married Thompson in March 1773, and asked Wedderburn to readmit his wife into the house as a servant, and also to pay him wages instead of his very small allowance. Wedderburn refused both requests, and Knight ended up living and working some distance from Belindian, and Joseph Knight decided to leave Wedderburn and to join her. Wedderburn, however, became aware of Knight's intentions and resolved to take every possible step to prevent his departure. He applied to the justices of the Peace of Perthshire for a ruling that he was entitled to enforce his slave services, and the order was duly granted. The decision was perhaps not wholly unexpected, as the hearing took place in Wedderburn's home, and he was related to two of the three justices. One of them also owned a Jamaican plantation, on which he employed Wedderburn's brother as overseer. Knight applied to the Sheriff Court at Perth, stating that the petitioner does not admit that he is a slave, but the sheriff's substitute refused to hear the matter on the ground that he had no jurisdiction, the case having already been decided by competent judges. Knight persisted, and his case was heard before the sheriff depute, John Swinton, who, on May 20, 1774, handed down a judgment which left no room for doubt or ambiguity. The state of slavery is not recognized by the laws of this kingdom, and is inconsistent with the principles thereof. The regulations in Jamaica concerning slaves do not extend to this kingdom. Wedderburn was determined not to let the matter rest, and the following year he applied to have it reconsidered by the Court of Session, the highest civil court in Scotland. Both parties were ordered to produce printed informations, written statements of their case, which they duly did, and the case came to trial in February 1776. But after several days of argument the matter was adjourned, and the parties were ordered to provide additional informations. These contained extensive further argument. The additional information for Wedderburn, prepared by one of his advocates, Robert Cullen, was 78 pages, and that for Knight, prepared by John McLaurin, one of the lawyers appearing for the slave, took up 44 pages. James Boswell, a friend of McLaurin, took an interest in the case and attended the February hearings. In June of 1776 he sent copies of the additional information for Knight to Samuel Johnson. Johnson replied a week later with a reminder of the precedent of the Somerset case. It was last year determined by Lord Mansfield, in the Court of King's Bench, that a Negro cannot be taken out of the kingdom without his own consent. Johnson had the year of the case wrong, but it was an accurate statement of the judgment. Clearly he had not read the additional information before replying to Boswell, or he would have known that the reminder of the judgment was unnecessary because Maclaurin had devoted several pages of the document to discussion of the Somerset case. However, Johnson subsequently read it and wrote to Boswell with approbation, offering money to support the case. "I have looked over Mr. Maclaurin's plea, and think it excellent. How is the suit carried on? If by subscription, I commission you to contribute, in my name, what is proper. Let nothing be wanting in such a case." The case still had not come to a hearing when, a year later, Boswell sent to Johnson the additional information for Wedderburn. In his reply Johnson wrote, "I long to know how the Negro's cause will be decided." 2 months later, Boswell and Johnson were both guests of John Taylor at Ashbourne, and on 23 September Boswell went to Johnson's room at night and requested that Johnson dictate a pleading in favor of Knight. Johnson did so, and Boswell wrote down the text. It was the only occasion on which Johnson set out a sustained argument against slavery. Its existence was unknown to the general public during Johnson's lifetime, and it would probably have remained so had not Boswell, in spite of his by then pro-slavery views, published the document in 1793. In fact, Boswell took some pains to ensure that Johnson's argument became public knowledge. He was unable to include it in the first edition, 1791, of the Life of Johnson. He had mislaid his copy, but he drew attention to the existence of the argument in the body of the text and, in a footnote, promised to make it available when found. He proved as good as his word. The second edition, 1793, of the Life of Johnson was issued in a hurry and without adequate preparation, and the resulting text was chaotic. Boswell was already reading the proofs when he located a mass of new material which included the missing argument, so he set it out in a separate section entitled, "Additions to Dr. Johnson's Life Recollected," and received after the second edition was printed. He also published it in a separate pamphlet of 42 pages, the principal corrections and additions to the first edition of Mr. Boswell's Life of Dr. Johnson, 1793, which was distributed, at Boswell's own expense, to owners of the first edition. The heart of Johnson's argument was a general statement of the natural rights of man, a statement which clearly reflected his understanding of Francis Barber's position, and which applied equally to Joseph Knight. The sum of the argument is this: no man is by nature the property of another, the defendant is, therefore, by nature free, the rights of nature must be some way forfeited before they can be justly taken away, that the defendant has by any act forfeited the rights of nature we require to be proved, and if no proof of such forfeiture can be given, we doubt not but the justice of the court will declare him free. On January 15, 1778 the Court of Session in Edinburgh handed down its judgment. The 12 judges expressed a variety of opinions, and reference was made to the Somerset case. Some thought that Knight remained a slave, while others decided that he was a servant for life without wages but that Wedderburn's power over him was limited, a subtle distinction, and probably not one likely to appeal to Joseph Knight. 5 of the judges were opposed to Knight's being a slave in Scotland, whatever his status in Jamaica. The strongest statement against slavery came from Boswell's father, Lord Auchinleck. Although, in the plantations they have laid hold of the poor blacks, and made slaves of them, yet I do not think that that is agreeable to humanity, not to say to the Christian religion. Is a man a slave because he is black? No. He is our brother, and he is a man, although he is not our color. He is in a land of liberty, with his wife and his child, let him remain there. In the end, the judges voted 8-4 to adopt the judgment which the Sheriff Depute, John Swinton, had handed down. The laws of Jamaica had no effect in Scotland, and the institution of slavery was inconsistent with the laws of Scotland. Knight, like Somerset before him, was allowed to go free. There is no evidence that Knight's advocates made any use of Johnson's argument. In any event, it seems unlikely that it would have influenced the outcome of the case, as there was little Johnson could usefully add to the 87 pages of wide-ranging argument already produced by Knight's lawyers. But if nothing else, Johnson's involvement did at least supply valuable moral support. It may be that, however indirectly, the presence of Francis Barber in Samuel Johnson's life contributed in some small measure to the ending of slavery in Scotland. The Somerset and Knight cases did not bring about a complete end to slavery in England and Scotland, but subsequent instances were rare. In the colonies slavery continued. Not until 1807 did legislation abolish the slave trade, and the Slavery Abolition Act was not passed until 1833. As for Barber, There had been great changes in his life since the Somerset judgment in 1772. That case had been followed by an outpouring of comment in broadsheets and in the press. The debate was often bitter, and the most virulent participant by far was Edward Long, who published a pamphlet in August 1772 entitled Candid Reflections upon the Judgment, on what is commonly called the Negro cause. For anyone who, like Long, was familiar with the lifestyles of the plantation owners, it was an irony that one of his principal concerns was the defilement of pure English stock by the birth of mixed-race children. The lower class of women in England are remarkably fond of the blacks, for reasons too brutal to mention. They would connect themselves with horses and asses, if the laws permitted them. By these ladies they generally have a numerous brood. Thus, in the course of a few generations more, the English blood will become so contaminated with this mixture. This is a venomous and dangerous ulcer, that threatens to disperse its malignancy far and wide, until every family catches infection from it. Long's views on race were the most extreme published in the 18th century, and historians have debated the extent to which they were representative or influential. What is clear, however, is that there was opposition to interracial marriages in some quarters, a fact which Barber was shortly to find out for himself. On Thursday, January 28, 1773, at the Church of St. Dunstan in the West, he married a white woman, Elizabeth Ball.